number 1.
Already here it is in the nature of a PIL. Although the trustee has filed against forcible demolition of the temple structure, a representation of the representation under Annexure 3 has been submitted by hand. So there is no acknowledgement. Your Lordship may grant me liberty. I will file a fresh representation that may be.
Okay. Counsel for the petitioner seeks leave to withdraw the petition, liberty to file a fresh representation to the authority. And after following up on such representation to seek approval in this accordance with law.
Obliged.
Item number 2.
Well, it is rendered infructuous.
All right, disposed of this.
Item number 3. Item 3. Sir.
And it appeal. Let's see what the matter is about. Appeal. All right. Same Gopinath Mishra. Yes. No issue.
Item number 4.
Memo taken on record. Disposed of is infructuous.
Item number 5.
My lord, item number 5. Because I was sick, I couldn't place the file. Your Lordship may kindly fix a bit to next week.
No. Counsel for the appellant says that the file is not traceable. Dismiss for non-prosecution with liberty to the appellant to revive it in case he finds the file.
My lord, next week.
Yes. You file an application. Whenever you find the file, you file an application. All right.
Item number 6.
Actually, matter infruction.
Disposed of is infructuous.
Item number 7.
Item number 7, Your Lordship, there has been some typographical error in the previous order, Your Lordship.
What does it tell us?
Your Lordship, it has been written as matter listed on 24 July 2013.
Yeah. The correction as pointed out, para 4 should read as list on July 24, 2023. All right.
And Your Lordship, 972 of 2023 also, Your Lordship. Case number has been written wrong. Case number has been written wrongly, Your Lordship.
All right.
Your Lordship. Deeply obliged.
Item number 8.
Lord, the petitioner challenged the inaction of the OP number 3 by the Annexure 1 series.
Item 8. Where is the proof of submission of this representation?
My lord, on dated 3/4/2023,
Where is the proof of the submission of representation?
representation by hand submit before the OP
Counsel to the
number.
petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation and after following up on such representation to seek appropriate representation. All right.
Item number 9.
Without considering the objection, my lord, OP number 2 has recommended to OP number 1. A similar order.
Perhaps the matter is pending before the government for taking a final decision.
This 31st March and all is over now.
That is already over. It is 3 months extended
3 months
for the pending cases.
Annexure 5.
You know,
Which
say that
date do we put here?
government will take care of this objection.
No. So
Last week.
not later than?
It is extended till April, May, June
I
30th.
said 31st May
My lord.
or 30th June.
First week of my lord.
This is not working. Yeah, all right.
Item number 10.
May I please, Your Lordship? As it is a PIL application, my lord. And illegal construction of the on the encroaching the Gochar and Basti Joga land, my lord.
Same question, sir. Just asking the question.
Pardon, man.
The mic is not on, sir.
Yes. Where is the proof of submission of that representation?
My lord, annexure. My lord, annexure 4, my lord.
Page code.
Before the sub collector, my lord.
But where is the proof, sir? Where is the proof that you have submitted that representation?
Even there is,
By hand, my lord.
there is no end.
Counsel for the petitioner,
My lord.
leave to withdraw the present petition. Liberty to
My lord,
file a
pardon,
fresh
my lord, by hand.
After following. such
Thereafter, they communicate with us on dated 27 by annexure 5, my lord. They also communicated a letter for our grievance, but no action has been taken till date. And by annexure 5, my lord.
It's again is handwritten, so some revenue inspector. You make a proper representation. Yes.
Item number 11.
May I please?
My lord, may kindly state, my lord. My lord, may kindly notice, may kindly be issued. They are going to be illegal constructed over the Gochar land, my lord.
So first make a representation.
My lord,
Properly
already
give it-
presented, my lord.
Get a proof of submission of representation, then wait for some time, then come to the court.
My lord, already represented, my lord. By annexure 4, my lord.
There
Already
is no
represented.
proof of submission of such representation. The proof you're showing is some handwritten letter. That's not good enough.
By annexure 4, I had filed, my lord.
If you don't understand, we're not going to repeatedly explain to you. I think my learned Justice Gauri Shankar has repeatedly asked you.
Yes, my
You're
lord.
unable to answer the questions.
My lord, pardon, mention, my lord. They have communicated to us by the annexure 5, my lord. May kindly see annexure
But
5, my lord.
that is a handwritten note.
Yes, my lord.
But that is not good enough to show that you have submitted that representation.
By the revenue inspector on dated 27/3/2023.
He's not an authority, sir. Revenue inspector is not an authority. I don't know why you're insisting on this. You have submitted a representation to whom?
Sub collector, my lord.
So get us a proof that the sub-collector has received your presentation. All right. Yes.
Item 11.
May I please? Lordship, in progress judgment is at page 75.
Item 11, my lord, pass over.
All right.
Item number 12. Item 12.
Madam, this is an application. Last order, my lord, kindly have a glance. Last order, my lord, kindly have a glance. My lord has passed the order on 1/2/23, 1st February. There, my lord directed the respondents to give the present position of.
What's the position?
I beg your pardon, my lord.
Because originally, my lord passed the order on 31st
Sir,
October.
permit us to ask a question to the other side, if you do not mind. Can we ask a question to the other side, sir? Can we ask a question to the other side?
No, my lord, I am
No.
myself. No.
Court ଚାହୁଁଛନ୍ତି ଶୁଣ
Oh, sorry, my lord. Sorry. Hard of hearing. Sorry.
Understood it finally. All right.
On behalf of Sri Bibisar Das, my lord, we are filing the affidavit today itself,
All right.
and I am giving the copy to my lord and
All
senior.
right. Counsel for the respondents 1 to 13 states that she'll be filing her affidavit today. And with a copy to counsel for the appellant, who's permitted to respond thereto for the next day. 16th August.
Oh, bless me.
Item number 13. Item 13.
Your Lordship's position. I just got late. If your Lordship pardons me, madam. In that 11, actually, we have appeared in January. I asked for documents. I have accepted the appeal memo. I don't have anything. If your lordship permits, will your lordship grant me 2 weeks time? My friend Mr. Kuntia is there.
Item 11.
With your lordship's kind permission.
In 11, my last occasion, lordship was about to.
Fresh notice to 2/16.
Yes, already noticed. So last moment, your file along my read petition. Last moment, I directed file fresh notice. Again, I file notice and they have appeared.
I have appeared for one party only.
Only one respondent.
One respondent.
What about 2 to 16?
That is opposite party number 2 only.
What about up to 16? There are some 16 respondents.
Again, I have filed the requisites and notice has been issued and the notice.
And the appearance date was fixed to today, your lordship. So therefore, others might have appeared, but their names might not have come. I appeared in advance, so the appearance date was fixed to today only in the notice form.
Neither AD nor undelivered notice received back from 5, 6, 10, and 15. See, Mr. Samir Mishra enters appearance for respondent 2. Then next line you say neither acknowledgement due card nor undelivered notice has been received from respondents 5, 6, 10, and 15. Fresh notice to the unserved respondents. Returnable. 7th August.
Obliged. Obliged.
7th August.
Item number 13. Item number 13.
None appears. Dismiss the normal section.
Item number 14.
Your Lordship, appearing on VC, Your Lordship. Your Lordship, Dr. Lenka has met with an accident, Your Lordship, on his wife.
All right. Counsel for the appellant is stated to be in some personal difficulty. August 7th.
Obliged, Your Lordship.
Item 15.
In item 15, notice has already been issued, my lord. And the office note says that opposite party number 4, they filed an affidavit, but that same has not been served on us. So let that copy be served and let the matter come thereafter. Because the main contesting respondent is 5, my lord.
Already I have filed Bhinama for respondent 5. My name has not been reflected. I have filed on 12th for 2023. My name has not been reflected. Respondent 5.
Mr. So-and-so appears for respondent 5 and states that he's already filed his Vakalatnama. It be traced out and placed in record. The affidavit filed by respondent 4 be served on counsel for the appellant. List on 8th August.
Obliged, ma'am.
Note 16.
Now, a counter copy may be served on me, my lord.
Item number 16.
In this case, I want 1 day time to prepare myself. This appeal arising out of order passed by the State Human Rights Commission. And the State Human Rights Commission.
The appellant needs more time to address arguments.
Item number 17.
None appears dismissed.
Item number 18.
Please, my lords. It's item number 18, 21, and 91 to be dismissed in view of the judgment passed by my lords.
All right. 18,
21, and 91.
Yes, yes, ma'am.
Grateful, my lords.
All right.
Item number 19.
May I please, Your Lordship? My lord, the order of Honorable Single Judge has been challenged in this writ appeal, my lord, because in identical case, the notice was issued to the respondents, my lord. In my case, it was disposed of, my lord. I have filed also a miscase to take up this matter along with that matter, my lord.
Which is that? Which is that other matter?
Your Lordship, may kindly say Annexure 16.
That IA has been rejected probably. My lordship, kindly see page number 225. IA has been filed by the petitioner saying that the similar matter notice has been issued, that IA has been dismissed. Page Miller 225.
Exactly identical matter, we have challenged the notification, my lord. In that case also, the notification is challenged.
No. What has happened in that other case? It's still pending the single judge.
Still pending.
Notice, he accepts notice. Are there other respondents? No, he accepts notice for the respondents. It's on 10th August.
Item number 20.
Highly obliged.
Yes, 20 contractual employee directed for regularization, 11th July.
11 July.
Item number 22.
None appears.
In item 22, my lord, 22. In that case, your lordship is directed to remove certain defects. It was removed. In certain documents I have applied for the copy. The lordship may kindly take it up next week. Any day next week.
26th June, defects be removed.
Item 23. 26th June. Item 23.
I'm just praying, Lordship, may kindly call it tomorrow. Today, the file was traced out in the morning. It's regarding fixation of pension, my lord.
All right. Counsel for the appellant needs some more time to list on. Like two applications. 22nd June.
All right. 25 is also same, my lord. 25.
22nd June, both.
Item 24.
24 rehabilitation, 30th August.
30th August.
Item 26.
There is some defect.
List on 22nd, defects be removed.
There is a IA, maybe there is a file IA number 1831 of 2023 in this case, maybe listed and sent.
We come with that only, right?
Item 27.
Item 27, I am for the appellant. The matter has been kindly said as infructuous. The matter is relating to recruitment matter in identical cases. Your lordship passed. Your lordship remanded the matter to the honorable single judge.
Subject matter is the same or different?
Different matter. But this matter also related to recruitment.
Yes, my lord. Same.
In this case, no counter has yet been filed. The government has taken time for filing a counter, but on that date.
All right. The impugned order.
Yes, my lord.
Reads as under. Counsel for the appellant maintains that the writ petition had not become infructuous by flex of time as it related to appointment of
Westman.
You did not appear in the Viva OC test of 2015 exam.
16.
What is your age?
I belong to my lord under ex-serviceman category. I qualified in all the tests. They are not allowing on the ground. I have no identity card, but I have the identity card. They have allowed me participate in the written test.
No. What is your age, sir?
Now my age, my lord, I have stated in my appeal petition.
He was 39.
39, my lord.
39 in 2017.
Now you are 45, sir.
Yes.
Now I am
22, you are 45. Come to your cost title.
Now I am 45.
How can you enter the service? What is the upper age limit for this?
There's a provision for relaxation also. I have to verify.
Since I belong to ex-serviceman category.
All right. Since it pertains to appointment to the OCS under the ex-serviceman cadre, he further contends that the cause of action still survives. Paragraph, it is seen that the petition was registered, writ petition was registered afresh after its transfer from the Odisha Administrative Tribunal. No counter affidavit had yet been filed, although time was sought for that purpose. Keeping in view all the above factors, the impugned order is hereby set aside, and the matter is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 18 July. The respondent state will file its parawise reply to the writ petition by 3rd July and rejoinder thereto, if any, before 18 July. No further time will be granted to either party for that purpose. The writ appeal is disposed of in the above.
Item number 28.
28, my lord, promotion during pendency of that vigilance case. 11-5, your lordship has
11th May.
Item 29.
29. 29. More, my 29.
29.
Sorry, my 29. 29, one pass over me. One pass.
All right, pass.
Item number 30.
30, my lord, 25-4, DLR employee regulation.
25.
Item 31.
31, my lord, 14th September.
14th September.
Item 32.
32, 25th April.
Item 33.
That rejection of review without notice, or similar matter, my lord already issued notice, fixed the matter to 14th July. Sorry, 12th July. 12th July. My lord, public.
Item 34.
34, my lord, 14th of September. Work charge employee.
Item 35.
My lord, as per the impugned order, the sub-collector has already passed the order. So I only pray that this order may not be treated as a precedent. That's all.
Considering these further developments, the court does not consider it necessary to interfere in the present matter. Nevertheless, it's clarified that the impugned order of a single judge will not constitute a precedent.
And the question of
And
law
the
is
question of law arising therefrom is left open for decision in some other appropriate case. The writ appeal is disposed of in the above terms.
I may pardon my lord, item 29, rehabilitation 30th August.
29, 30th August. Right.
Item number 36.
Lord, in this case, your lordship has directed us to obtain instruction about what is the financial implication. If the impugned order is implemented, what will be the financial implication? I have obtained the instruction, but there is only one copy, if your lordship will not mind.
All right, no problem.
That is more than 2 crores. The instruction is that so far as this particular GP is concerned, more than 2 crores we have to pay if the writ petition order is implied. And in addition to it, if the writ petition is, the impugned order is allowed to stand, then the entire Orissa farmers will also enforce their right on the basis of that. And then in that event, there will be a burden of more than 200 crores on state and central government. That is why I pray that let the appeal be admitted and
notice returnable. 21st August. There shall be stay of the impugned order in the meanwhile. You say a note has been submitted to the court explaining the financial implications of the impugned order on a single judge. The note be kept on record. Then you say notice returnable and stay in the meanwhile.
Date.
Giving the date.
21st August, sir.
17th. 17th. 21st. No. 21st August. Sorry. Correct. 21st August.
Item number 37.
Your Lordship, I'm appearing through VC on behalf of my senior Mr. G. Mukherjee. Your Lordships are requested to kindly pass over this matter. Obliged, Lord.
Item 38.
14th September, my lord.
Item 39.
25th of April, my lord.
Item number 40.
None appeals dismissed.
Item 41.
My lord, only 12 days delay. And also,
tell us what the matter is about.
My lord, some defects I will remove within this week. Next week, maybe any date, my lord.
I get second defects be removed.
Item 42.
14th September, my lord.
All right.
Item 43.
30th August rehabilitation.
Item 44.
14th September job contract. 44, 45, 46, 47. 14th September.
All right.
Item 48.
May I please, Your Lordship? My lord, the impugned order is passed by the Honorable Single Judge, my lord.
and the respondent number 1 and 2, and the 2 is the loanee and 1 is the guarantor, my lord. The bank has proceeded against the guarantor, and the approach this honorable court and honorable single judge have passed that order. Your lordship may kindly see the operating portion. Yes, my lord. Page 16, my lord. The outstanding is more than 6 lakhs some odd, my lord. And the bank has freeze his account, and the approach this honorable court, my lord. There is a honorable single judge, a director who opened the account, my lord.
But subject to conditions, sir. Subject to conditions.
Yes, my lord. Subject to condition, my lord. But the loan.
And this order was passed on 11th November.
Yes, my lord.
Have you complied with it or not?
Order is not complied, my lord.
It has been complied.
No, I don't know, my lord.
Why? You should know, sir. Become infructuous.
Complied already.
Since the impugned order has already been complied with, the present writ appeal has been rendered infructuous. It is nevertheless clarified that the impugned order will be treated as having been passed in the peculiar facts of the case and will not be treated as a precedent order.
Oh, bless you.
The writ appeal is disposed of.
Item number 49.
14 September, my lord.
All right.
Item number 50.
None appears dismissed.
Item 51.
Same order.
Item 52.
14 September.
Item number 53.
My lord, item 53, I'm appearing for respondent, my lord.
53 as
my lord,
20th July.
My lord, there is a delay of more than 9 months, my lord, and they have not yet filed the IA for condonation of delay, my lord.
So all COVID times, no problem.
My lord, the COVID delay is till March 2022, and they have filed this writ appeal.
The Supreme Court orders carries it beyond. This is first day disposal.
Yes, similar.
In this case, counter rejoinder has already been filed, my lord. This is the main case, my lord.
That was before last week, my lord. They sought for adjournment, and your lordship adjourned it to 20th July. The leading case. A batch of cases.
Same order, 20th July. 13th April.
That has been adjourned to 20th July. On that day, they sought for adjournment.
All right, 20th July. Correct.
53, 54, 55.
All right.
Item 56.
It is the 14th September, my lord.
All right.
Item 57.
It's on 25th of April.
Item number 58.
My lord, I'm appealing for the respondent. My lord, there's a delay of 253 days, man. The whole problem is COVID. They have taken in the IA, they have for condonation delay, they have taken the ground that delay due to interdepartmental correspondence, my lord. What's the matter about?
The matter, my lord, that's related to appointment, my lord. Your lordship may find it from page 83. 4 dates are important, my lord. Advertisement was issued in 2011. That provisional select list was prepared on 23/3/2013. Because of interim order by tribunal, appointments were not given. That select list was not operated. So that operated after vacation of the interim order. The appointment was given on 15/7/2014. So 2011 advertisement recruitment was completed on 15/7/2014. Another advertisement, fresh advertisement was issued on 22/1/2015. What has happened in the meantime? In response to that first advertisement, 4 persons did not join. So the director recommended their case to the government to consider their case for existing vacancy of 2011. Government rejected their case on the grounds since that select list has lost its force. After 1 year, they cannot be appointed. This is the case. So our case, once that select list has lost its force after 1 year, and that fresh advertisement has been issued in 2015, they don't have any right to be appointed even if their name finds place in the select list. The Honorable Single Judge have directed because that fault with the government to give them appointment. That is the case, my lord.
My lord, here the Honorable Learned Single Judge has already taken into consideration regarding the delay part, my lord. They are stating that after lapse of 1 year, the select list loses its importance, my lord. But here the advertisement was on back on 2011, my lord. But
they started giving appointment from 2013 and it lasted for till 2014, my lord. The important dates, my lord, may kindly note. My lord.
No, but after that, fresh advertisement has already been issued, sir.
But my lord, those vacancies, total 116 posts were there.
Those vacancies don't survive, sir. Once the
my lord,
is exhausted,
the vacancy arose.
Vacancies will be added for the next advertisement.
My lord, my lord, but it was not added, my lord. That was the thing, my lord. It was not added, and the 4 vacancies, my lord, the vacuum was only created. My lord, may kindly appreciate for a moment. My lord, the vacancies were created because the four number of candidates did not join, my lord. My lord, they two did not join, 2 did not come for counseling, my lord. And the 4 vacancies were not carry forwarded to 2015, my lord.
How can they not be, sir? They have.
And my lord, my lord, the interdepartmental correspondence took the time. For that reason, my lord, may kindly appreciate. My lord, the last paragraph, my lord.
Yes.
My lord, para 8 of the judgment, my lord.
Yes.
From the above narration, I may read, my lord.
Yes, yes.
It is evident that if the date of issuance of the first appointment letter is taken as the date of commencement of the validity of the select list, that is 16 June 2014, my lord. The same was due to expire on 15 June 2015. But as it appears, the select list was again kept under suspension as it were due to the aforementioned back and forth correspondence between the directorate and the government in between 9th March 2015 to 29 July 2015. In the meantime, the 1-year period expired on 15 June 2015. My lord, they kept it suspended and they took instruction. My lord, there was back and forth instruction regarding whether these vacancies will be included in 2015 or whether these the present respondent would be selected in that vacancy, my lord. My lord, for their latches, my lord, they're taking that ground that the select list has lapsed. If my lord may permit me, I'll file a counter to it, my lord.
Why? Your writ petition is already there. You say for the reason stated, the delay is condoned that IA is allowed. In the main writ appeal, you say lists for final hearing. On 28th August.
Item 59.
I stay up the influence. Stay up the influence.
Okay. In the meanwhile, there shall be a stay of the impute order. All right.
59.
59, 14th September, man.
All right.
Item number 60.
60, 61, 62, 63, 64, 14th September.
Yes.
65 also.
Right.
Item 66.
My lord, 66 and 67, my lord, I have not served the copy to the learned counsel for the state, my lord. Next week, any date, my lord?
List on 22nd June, defects be removed.
In the meantime, I will remove all the defects.
Item number 68.
68, my lord. I am challenging the order passed by the learned single judge. And in the meantime, the present respondent number 1 filed a contempt petition. Same was dismissed for non-compliance of the order. So hence the writ appeal is becoming infructuous.
Okay. And the writ appeal has been rendered infructuous on account of each subsequent developments. The appeal is disposed of as such. Right.
Okay. Item number 69.
My lord, 69, 70, 71, 72, 73, 14th of September, my lord.
Item 74.
74, Sartapata 8th May.
8th.
Item number 75. Item 75.
None appeals dismissed.
Item number 76.
76, my lord, old pension rule, 25th of April.
Item 77.
77, Sartapata 8th May.
Item number 78.
78, 79, 80, 81, 82, 83, 84, 85, 86, 14th September.
Right.
It is.
Item 87.
87, my lord, we are challenging the judgment passed by the learned single judge, page 17. The learned single judge disposed of the matter without us filing the counter affidavit, basing upon a judgment passed in Manas Kumar's 5, my lord. That judgment also we have annexed.
Yes. It doesn't apply.
Annexure 2, my lord.
It does not apply.
That judgment has been stayed, as I'm told. Verify the date, I'll inform you.
The learned single judge has in the impugned order relied on the judgment in Manas Kumar Swine, State of Orissa, 2021 OLR ILR Katak 357. The court is informed that the said judgment has been stayed in an appeal filed in this court.
My lord, that is different. Sorry. That's
Yes. Does this judgment apply or not, sir?
But it's not applicable. It will distinguishable because Lordship may kindly see in the judgment which has been referred. There, the disengagement order was passed by the, my lord, Lordship may kindly see page 48. Page 48 is a finding by this honorable court of a Lordship's order, my lord.
Gram Rozgar Sevak.
Yes.
But that's been covered by our order.
My lord,
There's a separate order that we have passed.
That is my lord's judgment.
In view of the judgment dated so and so, the present
WF 401 of 2017 on 19/9/2022.
It is pointed out that in view of the judgment dated 19th September 2022 of this court in WA number
401 of 2017.
401 of 2017 bracket State of Odisha versus
Gagan Bihari Patra versus State of Odisha.
Gagan Bihari Patra versus State of Odisha. The present appeal deserves to be allowed. Paragraph notice returnable on 27 June. There shall be a stay in the meanwhile.
Item 88.
88 on 14th September, my lord. 88, 89.
Item 90.
90 short, but 8th May.
8th May. Oh.
Item 100 matters. 100 matters.
Oh.
Item 92.
We put the CMAP in and appears dismissed.
92.
One pass over.
All right. Pass over.
Item 93.
May please your lordship. This is public interest litigation, my lord. Matter appears today's list as per order number 108 dated 7 February 2023, my lord. I would like to place the relevant paragraph of the said order. Para 3 and 4, my lord.
Your lordship has directed me to file further affidavit. I have given, they are preparing the affidavit. I'll take a very short adjournment because we have to collect materials from many sources and all the 3 medical colleges they will file.
Only a small submission to be made if your lordship permits, my lord. They have already consumed 1 year, my lord.
No.
Already 1 year. Why I say so? I want to draw your lordship kind attention to order passed in order number 103 dated 28/3/23, wherein this honorable court has directed to procure only limited prayer of the petitioner that they have to procure new and modern insulator, my lord. But as yet they have for 3 medical colleges they have to procure.
That order which my learned senior is referring, we had already filed an affidavit on 1st February 23. That is reflected in para 1 of the order number 108.
But they have not procured
that is not sufficient. That is why your lordship has directed to file for this.
And install on a modern insulator. May I pray let them comply to the order of this honorable court, my lord? Already 1 year has been consumed.
No, this is on 1st February till date. Only 2 months time. We had filed the affidavit on 1st February.
I may be permitted to draw your lordship kind attention to order number 103 dated 28 March, my lord, 22. On this said that this honorable court has directed the authorities to procure new and modern insulator, forthwith, my lord. But as yet they have not procured. For that reason, they have not filed, my lord.
All right. Counsel for the additional government advocate seeks some more time to comply with the order dated.
File affidavit pursuant to order dated 7th February
7th February 2023. The affidavit will positively be filed before the next date. Based on 3rd July.
This may be a last chance, my lord.
That's right. Last.
Item number 94.
Lord, pursuant to your Lordship's direction, my Lord. Lord, the Secretary Rural Development Department has filed an affidavit, my Lord. In the affidavit, my Lord, the Secretary has taken two, my Lord, stand. My Lord, the stands, my Lord, the first one is, my Lord, there was a, my Lord, resolution of the government under which, my Lord, that is dated 24th May 2017, Annex A1. Lord, where it has been decided that within a distance of 2 kilometers, my Lord, second bridge cannot be constructed. My Lord, the second point raised, my Lord, it will cost the exchequer to the tune of 14 crores, my Lord. My respectful submission before your Lordship is, my Lord, while the tender was invited for this bridge, my Lord, this was in existence. This letter was in existence. My Lord, tender was invited in the year 2019. My Lord, this scheme was there in the year 2017. In spite of the scheme, my Lord, they invited the tender. And the bridge for which I have filed the writ petition, my Lord, that is the first tender. And since that became the single tender, my Lord, the second bridge was, my Lord, the tender was invited. My Lord, the second, for the second bridge, my Lord, the tender became a single tender and it was again re-tendered. But for the bridge for which I have filed the writ petition, that was not re-tendered. Now they are taking the stand, my Lord, there is a distance of 200 kilometers, my Lord, 2 kilometers, my Lord, therefore the second bridge is not possible. My Lord, my submission, my Lord, this is a, my Lord, welfare measure. My Lord, these are people, are tribal people in a, my Lord, Naxalite infested area of Malkangiri district, my Lord. My Lord, the 2 kilometers, if the children come, my Lord, children have to walk 2 kilometers to cross that river, my Lord. And, my Lord, for this day laborer, they have to walk 2 kilometers to cross the river. Lord, now the, my Lord, vendor, my Lord, small vendors, vegetable vendors, they have to also come, my Lord, traverse 2 kilometers to cross the bridge. My Lord, second bridge can be possible, my Lord. My Lord, it is only to the tune of 14 lakhs as stated by the...
14 lakhs?
14 crores, sorry, 14 crores. Therefore, under your Lordship's order, my Lord, second bridge is possible, my Lord. This is my submission. My Lord, the stand taken by the state government, my Lord.
Lordship may kindly imagine all these are government policy decisions where the bridge
is all right, my Lord.
Subject to the public demand also. And my respectful submission is that in this type of matters, the interference of the court is scope is limited, subject to your Lordship's appreciation. But we have stated in our counter affidavit that it is within 2 kilometers. According to our scheme, it is not possible. These are the things which your Lordship is to consider.
Yes.
Because
on 21st,
Lord, your Lordship will find from Kotak to Bhubaneswar, Lord, 3 bridges are available within a distance of 200 meters, and, my Lord, besides another bridge in your Judicial Academy, my Lord. Therefore, if your Lordship's, my Lord,
you cannot
desire, my Lord, a second bridge is possible, my Lord. This is the dream of that, Lord, backward area people, Lord, tribal people, my Lord. It is only to the tune of 14 crores, my Lord, paltry sum for the government, my Lord. It is for your Lordships to decide, my Lord. My Lord, I have nothing more to say.
On 5th July 2021, the court had passed the following order. Thereafter, affidavits had been filed by the opposite parties. But the position as regards the second bridge in the area was unclear. We'll stop. On 2/12/2021, the following order was passed. Reproduce the order. Paragraph. Again, on 21st November 2022, after perusing the supplementary affidavit filed, this court passed the following order. Paragraph. Pursuant to the above order, an affidavit has been filed by Shri Sanjay Kumar Singh, Principal Secretary to the Government Rural Development Department, on 5th April 2023. Para 4 of the said affidavit reads as under reproduce para 4. Paragraph. Learned counsel, the petitioner urges that the second bridge would be at a distance of 4 kilometers from the present one and will therefore benefit the villagers who may not have to walk another 4 kilometers to cross a bridge. Full stop. There's no doubt that any order passed with this court issuing a mandamus to the government for a second bridge would have financial implications. And in this case, it is stated to be rupees 14 crores. Paragraph. These are policy matters of the government. as to where a bridge should be located and whether it is viable or not. These are best left to the judgment of the executive, as it is in a better position, keeping in view a variety of factors, to take a decision in that regard. The court is not satisfied that there are any compelling reasons to issue any mandamus to the government as regards the second bridge. The court, therefore, is not inclined to interfere. The petition is dismissed.
Item 95.
Lord, your lordship may observe one word. If it is possible, my lord, government may consider again.
No points. That's how the whole petition was.
My lord, we have filed the affidavit that cost your lordship has imposed. That is, we have filed the affidavit before date.
In response to that, I am filing a reply. My lord, today, I have also served a copy to my friend. Lord, here is they are constructing the Panchayat Bhavan over a Smashan land. Your lordship's first order was that before construction, whether there was any conversion or not. They took time and ultimately intimated to the court, no, there was no such conversion proceeding was initiated. Thereafter, they submitted that we are now proposing to give alternative site. My lord, they are providing the alternative site about 3 kilometers away. There is no connectivity. If your lordship will found their document, your lordship insisted them after my rejoinder affidavit file, your lordship directed them to file the map. And if your lordship will kindly have a glance to the annexure A/7 to the additional affidavit they have filed, there is in the bottom red mark, plot number 2352, the existing Smashan. They are taking it to plot number 259 in the top left-hand side, is a narrow strip of land about 10 feet by 120 feet. There cannot be a Smashan 10 feet to it that has been used by the villagers as passage. That cannot be utilized for the Smashan. And in respect of plot number 100, the document under annexure A/6, the Tahsildar filed an affidavit before this honorable court by annexing a document. The area is 27 decimal. And the Tahsildar now files an affidavit at page 78 of the brief. The area is 17 decimal. And I have filed a document that is the record of right prepared by the state agencies under annexure 6 at page 64. It's only 12 decimal. The state machinery is going to the extent of giving false information to this honorable court by stating a plot is 27 decimal. Thereafter filing an affidavit, it is 17 decimal. And their own document ROR, it is prepared by the state government by the settlement officers, which shows that it is area is 12 decimal only. And it is not fit for a Smashan.
Yes. So much discrepancy on the extent of the land, sir.
Yes, yes.
19 has become 17, has become 12.
He has given a reply to this just now. He has served the copy. May
you just check it?
No, may I request one thing to your lordship? Your lordship may direct the collector Jajpur to
make
look
a
into the matter.
Once your lordship directed the collector and the collector rejected our application.
Collector has never been redirected to look into all these rejoinders and whatever the stand taken and the subsequent events. We have shifted the place to some other place and revisit the matter.
Counsel for the petitioner has handed over in court today reply of the petitioner to the affidavit filed by opposite parties 6 and 7. First of Mr. Samal has pointed out to the discrepancies in the extent of the land in question, which is as per the latest affidavit of the Tahsildar,
yes,
stated to measure 0.17 decimal, which according to him is wholly inadequate for a Smashan. Mr. Mohanty Leonard AGA states that we'll have to seek instructions on the above affidavit. The written instructions be obtained from the collector himself. Full stop. Copy of this order shall be sent to the collector. Jashpur, forthwith. List on. Opening day will have 21st June.
May I say one thing more? While the Tahsildar is mentioning that it is 17 decimal, but the record of right shows it is 12 decimal only.
Bracket, whereas the record of right shows it is 0.12 decimal. Correct.
Item number 96.
So, some.
My presence may be recorded, my lord.
All right.
I mean VC, my lord. My presence may be recorded.
All right.
Item 97.
96 में कल पास ओवर मैडम 96. Pardon, madam. Item 96 kindly pass over.
Yes.
98.
97, your lordship may kindly pass over. 97.
Asked for 97 only.
He is for 96.
He is
All
for
right,
96
passed
and he
over,
is for
97 also passed over. All right.
Both passed. 98.
Item 98.
Your lordship, I have carried the writ appeal before your lordships. We agree with the order of the single judge, my lord, when the single judge directed the petitioner to procure the paddy, my lord. The difficulties I have stated in the writ appeal, my lord, the number of only including the respondent of 4, my lord, 513 tokens were allotted by the government to procure the paddy. But the miller tagged to the society, my lord, they did not raise or lift the paddy in time, my lord. That was informed to the respondents, my lord. The authority, government, state authority, my lord. They took no action against the miller, and also they did not tag any other miller to lift the paddy, my lord. That's why only 134, my lord, from the farmers of 134 numbers, my lord, the paddy could be procured, my lord. The rest of the persons, my lord, their token lapsed, my lord, as the paddy could not be procured in time, my lord. Now the respondent of 4 has approached this honorable court that his deliberately his paddy was not.
Who are you appearing for?
My lord.
Whom you are appearing for?
It is
for appellant, my lord. For appellant, my lord.
What is the grievance, sir?
Grievance, my lord, the respondent of her file a writ application before the honorable court seeking direction that his paddy could not be procured by the present appellant deliberately, my lord. And that's why the honorable single judge directed the appellant, my lord, to procure the paddy. But the difficulties on my part of the appellant, my lord, by the time the single judge passed the order, my lord, at that time the token given allotted to the respondent of 4 that was lapsed, my lord. And the miller, which were tagged to the society to raise the paddy, my lord, that was also cancelled, my lord.
This is an order of 17th August 2022.
Yes, my lord.
Now we are in.
Now we are
April 2023.
23.
What has happened in the meanwhile?
In the meanwhile, my lord, I have filed the appeal, my lord, the state appeal, because at that time, by the time the order was passed by the single judge, at that time this token allotted to the respondent of 4 and so other farmers, my lord, that has been lapsed, my lord. And that as the token has been lapsed, they cannot get the money.
Lapse.
Money has to be paid by the government.
No, what? So you have not implemented the impugned order?
Yes,
I came before the assault because that was not practical at the relevant time.
So once you file writ appeal, you give yourself a stay.
My lord.
Is that how it is done, sir?
My lord, if lordship directed the state, my lord, to tag the millers, my lord, to raise the paddy, I have no difficulties, my lord, to procure the paddy of the respondent of 4.
No. What have you done, sir? It's more than 5 months now. The impugned order is November, right? August,
my lord.
So more than 8 months now.
My lord.
So where's the question? You have not implemented the impugned order.
Yes, my lord.
So what remains?
My lord, your lordship has specifically directed token are issued to me in the month of February. But the farmers to whom they have purchased the paddy, Thereafter token were issued. My token was not lapsed. Deliberately they have not purchased.
You still have paddy, sir, with
My lord, is lying in stock in my house, my lord. I am a poor farmer. They have deliberately not purchased my paddy.
You say for over 8 months now, the
My
appellant has not bothered to implement the impugned order to learned single judge, which benefits respondent before, who is a poor farmer and who still has stocks of paddy which have not been procured. Full stop. Counsel for respondent before states that farmers who were issued tokens subsequent to him have benefited from the purchase of paddy by the appellant, but not respondent before. Paragraph, court is unable to find any error having been committed by the learned single judge in issuing the impugned directions. The writ appeal is dismissed.
Oh, bless.
My lord, if your lordship direct the state to tag, my lord, if I will, my lord,
There is a contempt that is to be.
my lord, kindly bear with me.
The contempt we say placed before the learned single judge, the roster bench, on 1st May.
My lord, difficulties, my lord, your kindly lordship bear with me. If the state will not tag the millers, my lord, to leave the paddy, how I can procure the paddy, my lord? Not only respondent number 4, my lord, more than 300 farmers, their token left, my lord. If your lordship direct the state to leave the paddy, I am to procure, my lord. I am to carry out the order.
Item 99.
May I please, my lords?
Yes, please.
Lordship may kindly peruse order dated 11/1/2023, my lords. Here, your lordships, while formulating the contentions at paragraph 2, my lords, may I just place that paragraph 2 minutes?
Yes.
It is contended that Mr. So-and-so, respondent number 4, was not a registered enterprise under the Micro, Small and Medium Enterprise Development Act 2006, in short, the MSMED Act, prior to the relevant time of the date of contract.
So this is coming up after notice.
Malas.
Who's for the respondent? You are for the respondent. Yes, what do you have to say?
It is a unity registered under in 1977. Well, that is what is the exactly order passed by the MSCFC saying that I am a PSC.
You are for respondent before.
Yes.
What about the others?
Others are state agencies. 1 to 3 are state. Respondent number 4 is the.
I am the contestant. So I am my registration is since 1979. But I'm giving a date, small date chart. Yes. The registration is 1979, the first right. Then, my lord, the Udyam Aadhar was issued to me and on 5/7/2018. Now, the period of supply.
No counter was filed before the single judge.
No, my lord, it was dismissed, expired without.
First date.
First date. And my lord, they have themselves.
If you have so much to say, he should be given a opportunity to respond to this.
No, my lord, I am on their.
How does he know?
My lord, I am on their case. Their document itself in the writ appeal.
You are on their case means you are not accepting their case.
No, I was the petitioner. I was the petitioner before the learned single judge.
I know. I'm saying no counter affidavit was even called for. It was on the very first day.
Unfortunately, my lord, the learned single judge, my lord, construed the permanent registration certificate issued by the DIC to be a registration under the MSME Act.
So anyway, my point is, if he had so much to say to defend his position, you must have been given an opportunity to respond to it.
Not his contention. Now, his contention before your lordships, my lord, has been noted by the learned single judge, and still, my lord, my learned single judge says that the PMT's registration by the DIC is a valid registration under the MSME Act. May I just place paragraph? No, page 35 is the impugned order.
Correct.
Page 35, your lordship see, my lords. Filing the writ petition, it is claimed proceedings initiated involving Annexure 11 is resisted by the petitioner being opposite party in the said proceeding on the premises that the petitioner establishment therein on the sole premise that the claimant herein was not registered under the MSMED Act at the time of supply of goods.
Do we permit him to file a counter affidavit here in the writ appeal or does
Let
it
him
go
file
back-
here. Let him file, my lord. Now, my lords, the entire issue, my lord, is the MSME authorities, my lord, they are holding, my lord, this PMT registration to be a valid registration under the MSME Act, and they have now referred the matter to the arbitration. And that's how your lordship's court, my lord, interfered in the writ appeal and have granted stay, my lords.
Well, I am just
And this
writing
is
two
contrary,
things.
my lord, this is contrary to
Respondent before hands
Well,
over a date chart.
Well, I'm just writing two things from their record. I'm not placing even for my
That no
counter.
affidavit was filed before the learned single judge. Respondent before will present it in the form of an affidavit and serve an advance copy to counsel to the appellant, who will be permitted within 4 weeks. The appellant will be permitted to respond to the said affidavit before the next date.
What am I beg to submit, my lord? My proceeding has been stayed and they have admitted in their counter that this 8 lakhs rupees is due to me. They have admitted and still they are not doing.
If
I'm just showing one.
if the particular person, my lord, does not come within the provision, my lord, provision of section 8, my lord, is violated.
Before your lordship admitting
Lord,
that.
admitting it's not a suit, my lords. It's not a suit. That I admit and I
I'm a MSME. They have filed 16 applications before them.
Your lordship may see, my lord, the date of application. Lord, your lordship may kindly see page 57, my lord, the date.
For 2017,
Yeah,
I have
please,
19, I have completed the work.
Your lordship
I
may
have not been
kindly
paid.
see at the end, my lord. Page 57, your lordship got it, my lords?
Yes.
The date of application for a registration is 5/7/2018.
Yes.
Your lordship got that date, my lords?
Yes.
And your lordship may just the previous page, that's page 56.
Yes.
This is the NBCC who has given me the work, and the paragraph, serial number 12. The work gets completed on 31st of March 2017.
Time barred anyway.
Months. And after, my lord, after 17, it's time barred, my lord.
Let him file.
My lord, just to look at that document of 56. My lord, 1 minute. I'm just, lordship kindly see that 56, column number 3, work order number. First of all, this is not a document of work order number, lordship said 12/11/2014. My work order is 2016, that is at page 16, page 53. So, my lord, they are completely false and misleading document. They have done this. My lord, kindly see
His own application note is in 2018.
Kindly see 55.
But can my learned friend
is there?
Let him file a counter, lord. Instead of joining issues with me, let him file a counter.
No, my lord, counter is, they have admitted the amount. I'm a MSME. My money is lying with them. And they are not. And 16, they have
order to cut. To file the affidavit.
Well, I have already filed the affidavit. I think that is, I have already filed with.
No. I'm sorry. He has not served any copies. He has just served.
This is just a date chart which you have given, sir. It's not an affidavit.
No, my lord, counter affidavit already filed. And also,
where is it?
When did you file the counter?
I filed in last week.
You have not given me a copy. No, you have not given me a copy. I'm sorry.
5th of April, I have filed a miscase for vacation of stay.
Neither the vacation of stay application has been served on me, not the counter, my lords. And my learned friend's name also does not appear.
The main writ appeal, you say Mr. Ratha, GM Ratha, learned counsel appearing for the respondent before, claims that a counter affidavit was filed on
5th of April.
5th of April. It is not on record. Mr. Karel and counsel appearing for the appellant also does not have a copy. You say copy thereof is served on Mr. Karel within 3 days, and also be the affidavit also be brought on record in the same time. The appellant is considering that no counter affidavit was filed in the writ petition. The appellant is permitted to file a rejoinder to the above affidavit before the next date. Then you say interim order to continue list on 22nd June. This IA number 1753 of 2023. Notice, Mr. Karel accepts notice. List on 22nd June. Right.
Lordship, I pray before vacation. My lord, Lordship can kindly consider my plight. The bankers are chasing me. 20 lakhs rupees is there due on.
He's approached the wrong forum, my lord.
No, that is exactly what the Lordship is to decide, and then I'll go to the right forum. I'm just placing my predicament. My lord, I'm a small enterprises. 20 lakhs rupees is due from them. They admitted in they admitted in the counter that about 8 lakhs rupees is due to be paid to me since 2019. They are not making payment. I have filed a miscase. If this is not maintainable, then I'll go to the appropriate forum. At that part, I say a small before vacation. Lordship, my please to.
Where are you located, Mr. Karel?
I'm located in Milord's. My head office, my lord, is in Bihar. My local office was in Khurda, my lords.
The only other option is mediation.
Sorry, my lords?
Only other option is mediation. Settle the matter instead of fighting it, spending so much on litigation.
I was pulled to court by my learned friend.
I know. But
and before a wrong forum. And I'm
all these are technical pleas at the end of the day.
And
if he is owed some money, negotiate, settle the matter. That's the best.
Your lordship will call it on the 22nd.
Anyway, litigate. You're going to have to defend. So you take a call. Both of you are businessmen. You should take a call.
And I'm drawing your lordship attention to
your lordship may call this matter.
Page 75.
Let me make a suggestion. Your lordship may call it on what is not there. That's not the language, sir.
All right.
So 22nd, my lord, your lordship are calling it notes. I'll try to make an effort, my lord, that there is a settlement, if possible.
I was ready before vacation, my lord. I pray. So lordship can consider
in the meanwhile, we open to the parties to seek to mediate the disputes to arrive at a settlement. All right.
Obligation.
Item 100.
Before vacation, lordship.
No, 22nd.
22nd of
June.
Yes.
Item number 100.
Lord, my lord, I pray for 1 week's time, my lord.
For what, sir?
On behalf of petitioner in WPC 32760.
Your lordship has directed this matter to be listed today in presence of senior advocate Mr. Misra, because it is a very urgent matter. Since 10th November 2021, we have filed the counter affidavit. Your lordship has taken the entire SIA permission. We have obtained the entire 7 queries remain on non-operational due to the interim order of this honorable court. That the villagers have foisted this case, and now they are going on illegal mining activities.
Yes. My lord directed 24/1 that the pollution board deputed team along with the experts, my lord.
Yes.
And the officials of the board, along with the representative of the chief district medical officer and the agriculture, we visited the spot and we have submitted the report, my lord.
Report is very much there. Last date also it was there.
And as per report, my lord, also
there is no infirmity in the order report.
Your lordship may direct that without consent and without environment clearance.
Yes, there is SIA. The annexure, I am annexed. Your lordship may see the copy of the SIA permission by letter number 23, annexure C/5 to my counter affidavit dated 20th November 2021. My counter affidavit, 20th November 2021.
Where is that?
Annexure C/5 at page 33. Everything is clear. When we are going to execute the lease deed in favor of the auction holders, or the highest bidders, this litigation, first they filed a litigation that was dismissed, another case here in this honorable court in the nature of PIL, and now it is going on. This is the history of this case.
My lord, we have not taken any adjournment previously. This is the first adjournment I am seeking. She is not well.
Last time, Mr. SP Mishra is unwell.
Mr. SP Mishra was there.
Who's unwell, sir?
Mr.
I don't know whether my learned friend is having power.
Mrs. Mohanty, I am telling from Mr. Mohanty.
Mohanty, no, we are on Mr. SP Mishra is in the connection.
Mishra was conducting the case, and Miss Mohanty was also vehemently, and in their presence, your lordship has
Mr. Mohanty is briefing Mr. Mishra. Is that it?
My lord, another
Mrs. Mohanty.
Mr. Mishra was engaged, my lord.
No, the name given here is Mrs. Baijayanti Mohanty.
Baijayanti Mohanty. She is also there on each and every date. She also.
Who was unwell?
She has filed the case, my lord. Today she is not feeling well.
She is not feeling well.
Yes.
So my lord, she and all.
Mishra was engaged, my lord.
In Orissa, I have to get used to that also. He could mean she could mean he.
My lord, may I only permitted to submit a few words, my lords?
Yes.
Recently, last week, there was a raid of vigilance raid in that Vichakhandi area of all crosser units. Not these queries, near Vichakhandi Mauja. And all the
queries,
yes?
31 queries.
Yes, 31 queries. And it is found that everywhere that the operation is going on and illegal mining is going on, that was some people are arrested. So why I am submitting this? By getting this stay order, they are not allowing us to execute the lease deed in favor of the bona fide lessees. And at the same time, they are all villagers. They are, that is my specific allegation in my counter affidavit, that all these petitioners of the same village, they are involved in illegal minings. There is a case of theft against them, and they are not allowing us to have the get revenue exchequer and get the mining operation in a legal manner. That is why another PIL is also filed that the operation should be started legally and there should not be any impediment for that.
So we'll do one thing, we'll vacate the interim order, keep
Yes.
the petition pending.
Yes.
Whatever they do will be subject to the
Subject
outcome
to
of the
the-
petition.
Yes, my lord. Yes.
All right. In view of the report of the Pollution Control Board, which has already been examined on the previous day, but and
My lord, it may adjourn to next week any date, my lord. 1 week, my lord.
Yeah. in other that the state government has been taking action against illegal mining in the area.
My lord, there is a IA filed by us for vacation of the interim order 17114 of 2022
Just put
at
down
flag B.
1711 of 2020. This is an application for vacating the interim order passed by this court
On 10th November
on 10th November
2021.
2021. Paragraph. This court has perused the report of the State Pollution Control Board and has also examined the affidavits filed in the matter. Having heard counsel to the parties, the court is of the view that the impugned that the interim order passed by this court on 10/11/2021 should be modified. To stop it is accordingly directed. While vacating the stay granted on that date, the court clarifies that all actions taken by the opposite party, state and pollution control board in the meanwhile, will be subject to the outcome of the writ petition. The IA is disposed of in the main
And the
petition.
stay order stand vacated because
Yeah,
there
I've
is a
said that
stay order.
while vacating, I've said.
Your lordship, right? That
Yeah, I've said that, sir.
yes.
It's dictated. When you get the order, you will get it. In the main matter, you say, court is informed that Mrs. Baijayanti Mandri, who appears for the petitioner, is unwell today. List on 26th June. Right.
Pastor. Weekly list pastor matter item number 37. Item number 37.
May I please your lordship? My lords, on the 20th of December, I had filed IA number 4081 of 22 for substitution of the writ petitioner. That application has not come on board.
I see. IA number?
4081 of 22.
Mr. Mukherjee, senior counsel for the appellate states. They have filed IA number 4081 of 2022 for substitution of appellant number 1 by his legal representatives. The said application be brought on record.
The sole appellant. my lord.
Yeah, sole appellant. Right. List on 11 on the opening day, 21st June. All right.
Pastor matter item number 92.
May I please?
There are some defects in the CMAPL.
Copies I have served. 3 sets on the previous date. Direction was given to file 3 number of copies I have served. The mistake of the advocate so that it
No, but there's a huge delay in filing the CMAPL. Where is the application for delay?
Yes, there is a condemnation of delay. I in this case 176 of 2016.
How much is the delay? 917 days, sir.
917 days, yes.
That is only due to the mistake of the advocate because I have also filed the monthly list also I have filed. Generally, we used to maintain in our advocate's office. Your lordship may see that annexure 1, I have filed that original also is with me. I found that it could not be marked, missed the list so that it could happen. And this is on the merit also, there is a strong case as the petitioner was the only candidate who applied for the post of this to be appointed as notary in the year 2005. and only one candidate out of 6, 4 were lying vacant in Udala circle.
Now this post must be filled up. That Udala,
No, my lord,
there's no notary in Udala for the last 10 years.
thereafter, I have mentioned, my lord, how things have happened during the pendency of that case. Once again, some advertisements were made. And earlier also, this petitioner advocate approached this honorable court where direction was given that you should consider the case of the petitioner. If he is.
The question is, this is which area? This is which area?
Udala district of Mayurbhanj.
So are you trying to tell us that in this Udala, there is no notary public for the last 10 years?
No, there were out of 6, 6 posts were out of 6, 2 were there, 4 were lying vacant. For 4 posts, only one single candidate, the petitioner, applied for the post. Then in law, there is no alternative than to give him the appointment till 2009. 2009, some amendments came for which that committee is to decide. Well, earlier, there was no committee at all. As per the rules, section 5(7), it is to be appointed. Notaries rules 1958. But thereafter, in 2009, the amendment came that one board is there. A board is constituted who used to find suitability of the candidates. And here, may I take your honor to the provisions.
1 minute.
That
you're not setting out the facts properly. Where's the first provision?
Yes,
what are the dates? What is this?
I have given. I started my practice in the year 1996. Then in the year 2005, when I came to know about lying of this post of notaries, I applied in the 2005. And in annexures, I have given all those requirements have been fulfilled. Because the competent authority is the district judge, I have approached them and accordingly documents were, the district judge has also inquired about the matter and cleared. Then the Secretary Bar Association, they have cleared. I have annexure 4, your lordship may see, annexure. All those documents are there. And in spite of that, when they did not publish the result, then I applied under the RTI Act. And may I take your lordship to page 19, then it will be clear to your lordship. Page 19.
May I suggest,
Page
if
19.
my learned friend will agree, let him apply afresh. So that
2012, and once again I applied, but it was not considered. I was not called for the interview. 2010, I have mentioned, I have filed those documents. In spite of the direction, may I take your lordship to annexure that all those documents, annexure 1, 2, I need not have to spoil the time. Annexure 1, 2, 3, 4, all those paraphernalias I have performed, and the competent authority district judge also recommended my name. Then may I take your lordship to page 19. That is annexure 8. With reference to your memorial dated 5/5/2000 on the subject mentioned, I am directed to say that you are required to appear.
So petitioner is a lawyer, I presume.
That you are.
Madam, the petitioner is a lawyer.
Yes. Notary only lawyer can apply.
Very good. We were never aware of that. So thank you for informing us. The lawyer is unable to follow up on his case, correct? For 900 days? The delay of 900 days, the lawyer is pleading ignorance.
The advocate appearing, my lord, it is my mistake. Not that.
So your client is a lawyer, correct?
Yes.
So the lawyer client also is no different from other clients.
Yes.
Yes. You're seriously saying yes.
No differential treatment, my lord. All are equal in the eye of law. So that, but what is.
Madam, you're not understanding the question. See, beyond the point, we cannot keep on asking you questions. Do you understand the question or you don't understand the question?
Your lordship may repeat it once.
I'm tired.
If I have not understood it.
Madam, tomorrow you will again tell another court, because of my mistake, don't punish my client, right? This is your case and you are unable to understand the question.
No, my lord.
1 minute, let the question be repeated, then you apply your mind to it.
Yes.
Is there any difference between a lawyer as a client and an ordinary client?
So, more the advocate clients should be, in my opinion, more diligent is expected. Correct.
At least on that you agree with us, which is a good sign. This is a good sign.
To agree.
We have actually begun with a good note now. For once you are agreeing with us. Now explain how many days delay?
917.
917 days delay. Now you explain it.
Yes.
Put your best argument forward. Let us see. How many years experience in the bar, madam?
Only 32 years.
Only 32. So put your best argument. Yes. Now show others why a 32-year-old lawyer is better than other lawyers.
That I cannot say. Sometimes 1 year are also better, my lord. Anyway, may I take your lordship to page 3? I have mentioned that in 2016, the advocate for the petitioner filed memos twice, thrice, and also I am having some Xerox copies. Then when the matter could not be listed, then I inquired in the office.
See,
then I came to know that
the problem is not preparing for this application the way you should prepare. All right.
Yes.
When was this writ petition first filed, madam? That is how you should start. When was this writ petition first filed? Are you aware of the date?
Yes, madam. That is 4671. That is filed on 26/2/2013.
Very good. Next. What is the next date?
There I have.
Where is the next date? What happened after that?
Next date is, my lord. Then 13/12. I have given the explanation that 18/3/16 I verified from the.
Madam, there is a date. Okay. There is a date after that.
That is. There is a. It has not been listed.
No. That is the problem. Because you don't have the order. You are not the lawyer, correct? You are not the lawyer then, correct? It does not appear that you were the lawyer. Please show her the paperwork.
Case was filed.
No, we'll help you.
When the matter was listed,
there are what are two judges there for? Only to help you. We'll do all your research, pull out all your orders.
Yes.
Now read. There's an order of 11th December 2013. Please read that order. You're now reading it silently.
Yes.
You should read it for our benefit now. See, two old judges may not get it right unless the benefit of reading the order by the lawyer is there, right?
Yes.
Please read it.
1 week time is granted to remove the defects, failing which the matter shall stand dismissed without further reference to the bench.
What is the meaning of this order? What is the meaning of this order?
Then accordingly, it was dismissed. A peremptory order was passed. Thereafter, it was dismissed.
There is one more date, right? This is 11/12/2013.
Yes, madam.
How much time was granted?
1 week time was granted.
When did that 1 week expire? See, I think for people watching this matter, they will be wondering why are these two judges wasting time on a small matter like this?
5 to 14, it was.
See, for the last 20 minutes, you have been trying to get facts, correct? Now you understand what we mean by facts. Facts relevant for your application for condonation of delay of 917 days. So is this a relevant fact? What you just now read is a relevant fact.
Yes, 5 to 14, it was dismissed.
Madam,
Then-
what you just now read is it a relevant fact?
Yes, certainly.
Which
And
is the
I-
next
accordingly, I have-
date which is relevant?
Yes, ma'am.
When did this 1 week expire?
That from 2/11/13.
11, 12, 13, madam. That's order number 2. The date is 11, 12, 13.
11, 12, 13.
When did 1 week expire?
11, 12, 18, 12.
Very good. Full marks. So we are now in agreement on that also. Just look how good progress is being made. So 18, 12. Please note down that date. So first relevant date is 26/2/2013. Second relevant date is 11/12/2013.
Yes.
Third relevant date is 18/12/2013. Now fourth relevant date is the file is with her.
Yes, madam. That I have mentioned.
No, you
And
take the trouble.
accordingly, I have
Give me the
challenged
file. We have even given you the file. Please open that file. This is the original file of the court. Now come to order number 3. What is the date?
That is 5 to 14.
How longer did you wait? Your date expired on 18.
Yes, ma'am.
We have waited till February 5/2/2014.
Yes, ma'am.
How many more months you had after that? Nearly 1.5 months.
Yes.
What did you do in that 1.5 months?
Yes, madam. I am coming to that.
Come, please.
Yes, both the dates, that is 11, 12, and 13, and 5 to 14. That was not.
You must remember you're an advocate. All right. You're not an ordinary person.
In my list, annexure 1,
And
I
you
have
want to be a
mentioned.
notary. You're an advocate who wants to be a notary.
Yes. 11, 12, 19. Annexure 1, may I take your lordships to? That first order, it was, when it was listed, peremptory order was passed. That was not within the knowledge of the advocate as he missed the list, the conducting advocate. That I wanted, that I have mentioned.
Then
that the original copy is with me, as Xerox copy I have filed. And as such, both the dates I have filed now for passing of both the, that recalling that order, both that 5, 11, 12, 13 and as well as
not
5
within
to
whose
14.
knowledge? Come to 11/12/2013.
Yes, madam.
Is there appearance of lawyers?
No.
11/12/2013.
Yes.
Madam, after this, just listen. After this, 1 minute, just listen, please. After this, don't expect us to be very patient. All right.
Yes.
Now, please start answering questions.
No advocate appeared on that day.
Madam, we'll really lose our cool and patience now. Just lift that file.
Yes.
Just lift that file. 1 minute. Just lift that file.
Yes.
Open that 11/12/2013.
Yes.
Do you find a name of an advocate or not?
No. No, it is not there.
Just give it to him. Just 1 minute.
What
Just
has happened?
1 minute. Just give it to a colleague of yours. Just sir, you get up.
Yes.
Just see that 11/12/2013. Do you find the name of an advocate or not? For the petitioner.
Yes, Mahanti advocate.
Sir, do you find a name of an advocate or not?
Oh, that
Why don't you say yes, sir?
For the
Do
petition.
you find or you do not find?
You
do find.
Opposite parties.
What is wrong with you?
Yes, no.
What is wrong with you?
11, 12, 13. Yes, I could not see it properly, but there it is.
We are going to really lose our patience because you're wasting the time of the court. You're completely wasting the time of the court.
Yes, Mr.
You're trying to help you so much.
Nobody is there. Maybe my mistake, my lord. Mr. Yesh Mahanti. Nobody is there in my office. I have to look to the Bhaklapnama.
You don't bother to inspect the file. You don't bother to take the copies of the orders. You don't bother to prepare a list of dates. This is the kind of assistance we're getting.
Extremely, I am sorry, my lord.
I don't know who has to be sorry. I think we are feeling very sorry.
Most probably that
This is the next one. So it's a peremptory order passed.
sorry, my lord. Extremely, I am sorry, my lord, because it is Mr. S. Mohanty, it is written. I thought that nobody in my office, but it is Shruti Mohanty. See, Mr. S. Mohanty, it is written, so that I was under the impression that nobody in my office, my associate named as Mr. S. Mohanty is there.
What's the correct answer? I think everybody should know what the correct answer is. What is the correct answer?
Extremely, my lord.
No.
I'm
What is
sorry
the
for
correct
that.
answer? What is the correct answer? Take that Vakalatnama.
Vakalatnama, I got it.
What is written in that
That
Vakalat?
is Smruti Mohanty.
Who's
one is
your
there.
associate?
Yes.
And you have co-signed that Vakalatnama.
Yes, madam. She's there. No, I can't go beyond that.
Actually, I must confess to you,
Here it
I am
is.
amazed at my own patience today. I am amazed at my own patience. You have misled, you have given wrong answers and misled the court 3 times now.
Your lordship is
I don't think
absolutely
today's
right that
I don't think today is your
could not.
I don't know about your 32 years of practice, but today is not your best day. You have made 3 huge blunders and you still want orders in favor of your client. Correct?
Yes. Suppose I have made the mistake, my client should not
So
suffer.
now,
That is the only ground I can.
now you want to still persist today, or you want some other day to try? You still want to persist today, or you want to try some other day?
Your lordship is absolutely right. Other day, and I shall prepare a date chart. Then your lordship may take up.
All right.
After vacation, any day.
Kindly return that file now.
Yes. Obligement.
Counsel for the applicant seeks more time to properly prepare for the matter and address arguments. List on 27 June.
27 of April.
June. Pastor matter item 96. Item number 96.
On the case of writ appeal, my lord, I am challenging the order dated 13/11/2007. My case is covered under OGC 6339 of 97, Nirmala Naik versus Great Corporation of Odisha, my lord. That has not been considered and the impugned order passed. That should be set aside, my lord. Clear court of electrocution death, my lord. I have filed several citations before lordship that file. The appellant's husband, my lord, found a naked wire lying on the road. After super cyclone, it was not maintained by the opposite party. Only my case is single out, my lord.
You are now Utkal Mishra.
My lord.
Okay. So this is correctly now mentioned. So what were you to do in terms of the last order? You want to prepare and cite case laws.
My lord, I have filed, my lord. already filed on the file, my lord.
What have you filed?
Case law, my lord, 6339 of 1997, and other judgments, my lord, Honorable Justice B. Gopal Gowda, and other judgments, my lord.
Likewise.
Only I have to file, my lord, written notes of submission, my lord. So if your lordship permit me, then I'll file.
No. What is the matter? But what is the single judge's order? Where is that? Which page is single judge's order?
Page 13, my lord. Page 13.
Page?
Page 13, para 5. Relevant, my lord. Although the Lord and Counsel for the petitioner submitted that the husband of the petitioner had received electrical shock by coming in contact with a live electric wire while he was going to a temple. Inquest report reveals that the deceased was found wearing a lungi and a towel and holding a naked electric wire in his hand. This court therefore entertains no doubt so as to whether the accident occurred while the husband of the deceased was going to a temple. Lord and Counsel appearing for the opposite party, on the other hand, has submitted that due to cyclone, the electric wire has snapped and the supply was disrupted.
Basically, the single judge is saying disputed questions of fact and therefore go to the civil court.
Yes,
my lord, it has already been decided by the OJC 6339, 1997, my lord. Paragraph 11 to 15. For total, my lord, I have filed that judgment. One High Court judgment and other air supporting judgment, my lord, Supreme Court decisions. Death is not disputed and the part of negligence, my lord, of the electric department.
That is disputed, sir. Whether
No disputed. It can be decided, my lord, in the read jurisdiction. Paragraph.
No. If it is undisputed, it can be decided, sir.
No, my lord. Everything it will be decided.
No.
Lord, Honorable Justice B.P. Das and A.K. Samudra, my lord, judgment.
All right.
OLR 2005 to OLR 389, my lord.
Right.
All things has been narrated, my lord.
All right.
Whether it will be decided or not. Paragraph 15, my lord, it has been decided. After hearing both the Lord and Counsel and elaborately considering the questions raised by them as discussed above, we have not the slightest hesitation in coming to a clear and cognate conclusion that this writ petition under Article 226 of the Constitution is maintainable and the opposite party's corporation is liable on the principle of strict liability to pay compensation to the petitioner in the present case, my lord.
That's right, sir. Each case will turn out on its facts, correct? Each case will turn on its own facts, correct?
My lord.
Now, in the facts of your case, they are disputing that the death occurred due to negligence of the electricity company. They're disputing that, sir. Just come to the impugned order of the single judge. Kindly come to the impugned order, sir.
My lord. The impugned order is oversighting the judgment, my lord.
Sir, please read the relevant paragraph. Para 2, sir.
After receiving rule, a counter affidavit has been filed by the SESCO, refuting the aberrations made in the writ petition. Is specifically pleaded that the death of the petitioner husband has occurred due to his utter negligence while he was taking lead in the clearing the branches of trees that fell on the road due to cyclone. In the process, he came in contact with a disrupted electric wire lying on the road. A number of documents, including an FIR lodged by the junior. My lord, this FIR is not registered by the police. My FIR is registered. They have filed that counter annex this FIR, my lord, not registered by the police.
So come to para 3.
After hearing the Lord Counsel for the party, this court finds that there is no dispute that 19/8/2003 at about 8:30 p.m. the husband of the petitioner has received the electric shock and succumbed. It is not my fault, my lord. It is.
Sir, then we should not read. Don't read in a truncated manner, sir.
when we ask you to read, you should write.
The only question that needs consideration is to whether the deceased has received related shock due to the negligence of the opposite party or in his own. Milord, this was lying on the road, Milord.
Correct.
He was going to the puja of Janmashtami.
Sorry?
For performing the Janmashtami puja.
We don't know that, sir. You're just saying it. If you went to the civil court, you will have to establish this fact, right? They are saying you're looking to remove the wood from the trees lying on the road after the cyclone. That is their case. Your case is you are going to a temple.
In that judgment, 1997, it has been decided, it can be decided in the writ court, Milord.
Everything can be decided if the facts are not in dispute.
And the duty of the department to take all safety measures to prevent escape.
That's right.
Or such energy and to see that.
This is post-cyclone. You have to imagine a situation. What happens in a cyclone? You are a resident of Odisha, correct?
Yes,
what happens during cyclone, sir?
There is a cyclone, Milord.
Correct. What happens usually in the cyclone? When there is a cyclone, what usually happens?
No, normally uprooted the trees and electricity wire will be lying on the road.
So whichever, even the best electricity company, even in United States, anywhere, best electricity company also cannot quickly repair all the repairs of the electric wires, correct?
No, they have to manually suspend or automatically revise to be installed, Milord. That is the case.
So do you understand? Anyway, I don't think you're not interested in understanding what the issue is. In law of torts, when I say law of torts, I hope you understand. There is something called standard of care, correct?
My lord.
For negligence cases, there is something called standard of care. Are you aware of that, sir?
My lord.
Cases involving negligence in the law of torts, there is a principle of standard of care. Have you come across that?
All things, my lord, decided on that judgment, my lord.
Sir, I'm asking some question, you're answering something else. Have you picked up a book of law of torts when you prepared this petition? Why don't you ask?
Have you referred to any law of tort while preparing this petition?
No, I have studied the decision of Honorable Justice B. Gopal Gowda's. I have filed that.
Sir, Justice Gopala Gowda also refers to this in his judgment, sir.
My lord.
Have you seen that? Or you said Justice Gopala Gowda has said it, so no need for me to read it.
It is also stated in that judgment, my lord. This is a lot of compensation.
Sir, Justice Gopala Gowda has taken the trouble of telling you something about law of torts in his judgment. Have you read the law of torts? Suppose in today's judgment, we refer to Justice Gopala Gowda's judgment. All right. Will you then read Justice Gopala Gowda's judgment, or you'll say, no, these two judges have talked about Gopala Gowda's judgment. I need not read Gopala Gowda's
judgment. No, I have read, my lord.
You will read, huh?
Yes.
So suppose Justice Gopala Gowda is referred to law of torts. Will you read law of torts? No. So Justice Gopala Gowda said it. I don't need to read it. How will you understand whether that law applies to the facts of your case?
So many decisions and
too much trouble, no sir, too much work. You're saying, don't ask me to do so much work. Do you have to help your client, no sir? We both have to sit and help your client to get justice, correct?
My lord.
And you have to help us do that. You have to place the correct law before us. If we simply say we agree with counsel for the appellant, we allow the appeal, that electricity company will go to Supreme Court and said, what is this? No law, nothing. In 2 minutes, it will get set aside. Then how will you help your client? You have to help with placing correct law before us, correct? That's right. So only ground, suppose we both say appellant is poor, writ appeal allowed. Do you think Supreme Court will uphold it?
No, my lord.
It will not, no?
Clear court electrocution death.
No, there should be some law. Some law has to be referred to, no, sir? Can we simply say, client, your appellant says the appellant is poor, therefore
impugned order set aside, writ appeal allowed. Will it be an acceptable order, sir?
2 weeks time, my lord, I am allowed.
So in this 2 weeks or whatever time we are giving you, please pick up any standard book on law of torts. All right.
My lord.
You are trying to establish negligence, correct?
Yes.
When you establish negligence, you have to see the circumstances. There is no reasonable, the position of what you call a reasonable man. In a similar situation, what a reasonable man would have done, right?
My lord.
Would that standard of care that is expected, was it adhered to or not adhered to? If you are appearing for the electricity company, what would you plead? You'd say cyclone, act of God. Will you or will you not? Have you heard of that expression, act of God? No.
No, ma'am.
Anyway, I think we have to go back to your LLB days. We'll also go back meanwhile to our LLB days. So what you do is you pick up a standard book of law of torts, study the chapter on negligence, you'll get a variety of cases, including what we're discussing now, electricity shock. There are numerous cases of deaths due to electricity shock, not only in our country, in other countries also. Then you'll understand in this situation, what is the standard of care, whether this electricity company exceeded or did not exceed or complied with. All right.
My lord, 20 years already been passed in this case, my lord.
What to do? Still the law, we still require the law. What to do? Very adamant judges we are, sir. We insist on law being prepared, law being presented to the court. Therefore, that's a problem. All right.
No, sir.
Counsel for the appellant wants more time to prepare his arguments in the case. He states that he will prepare a written note of arguments before the next date. June 28.
Item number 97. Please, your lordship. My lord, an advertisement was made for filling up the post of an Anganwadi worker as per the guideline of the Panchayat Raj Department dated 8/6/1992. The advertisement was made on 27/1998. According to that guideline dated 8/6/1992 of the Panchayat Raj Department, the Anganwadi worker shall be a lady with the age group of 18 to 44. I have given that English version of that guideline, my lord. Clause 1.1 of Annexure 2 provides that
yes,
the Anganwadi worker shall be a lady within the age group of 18 to 44 years who should belong to the village where the center is located. The present appellant made an application for the said post as he was within that age group, my lord. And the application was made by the...
So today that upper age is what?
Upper age is 45 years.
45. Yes. Today she's 44.
40. No, upper is 40. 40, no, 45. Revised guidelines. Revised guidelines 45. That is, it has been revised also. 44, 45.
What is the exact date of birth of this woman?
Exact date of birth, my lord, let me see. If I have the document, I can tell you. 4th March 1977.
47.
46.
46 already, sir. So she's crossed.
46 already. And that date will be taken into answer on the date of advertisement only.
No.
Not present age, my lord.
Okay, today they can't take a 46-year-old.
That present age, my lord. Present age cannot be taken into account, my lord. It is my humble
No, she was never appointed, sir. This is not a case where she's appointed and then terminated.
My lord, I have been deprived of, my lord, being considered, my lord. Law says that, my lord, what they did, my lord, then subsequent that guideline
Mr.
came
Murthy,
into
you are
force.
press person, you were aware. Suppose she'd been appointed, then for some reason that order has been cancelled, and then she's trying to get back. Different considerations. But she never got in the first place.
No.
So
No, first one. That is, case is not that, my lord. Case is here, my lord, the guideline was again published on 7/10/1998. After the advertisement was made and I made application, much prior to that on 37, I made the application, my lord. There in the new guideline, the minimum age was fixed at 21 years, my lord. So, without cancelling the advertisement, they made it 21 years minimum age and rejected my candidature.
that's right. But what I'm trying to tell you is she therefore never got in.
Yes.
No, my candidature was rejected on the ground
whatever
that they considered the applications as per the new guideline that is dated. I'll give you that date, my lord. 7/10/1998, my lord. The last date of making application was 10/8/1998. After 2 months, the new guidelines came into force, my lord. How could the selection be made on the basis of new guideline, my lord? That is the sole question before lawsuit, my lord.
See, the question, therefore, sir, because of passage of time, she's crossed even the maximum age now.
My lord, it will
So
be
today she cannot join, sir. It's a simple question.
My humble submission before lawsuit is that now the case will be adjudicated on the date of advertisement, what was my age, my lord.
No, you may succeed in terms of establishing that on that date you were whatever, not above 21, but you fulfilled the terms of the advertisement. The rule was changed after the advertisement.
Yes.
Therefore, you were wrongly deprived of selection. All that is fine.
Yes, my lord.
But today you're 46.
I can get the appointment, my lord.
Under what law? See, there is a limit to how much a court can overlook all of this.
If a lawsuit says that
so there will be a lot of damages.
Not age bar, my lord.
No, it is true, sir. Today, that we cannot deny. Today you are 46, we can't deny.
Whether this the applicant's this case can be considered, her case can be considered or not, my lord. That is only one point according to your lawsuits that it will.
No, she may not get relief because she's 46. You must still establish the point that wrongly kept out.
This point is raised by your lawsuits. I will, my lord, give you answer. My lord, will also give me some time, my lord. I will give the answer. Your lawsuit.
This is what a good advocate is. You're proving why.
No, that query your lawsuit made that today. My
all right. You say the appellant has already crossed 46 years. However, Mr. Mohanty, learned counsel for the appellant, argues that she was wrongly denied an opportunity to be selected as Anganwadi worker when she first applied for the post. And it is only on account of the pendency of the litigation that today she has crossed the maximum age. According to him, she should not suffer on that score. Paragraph. When asked to substantiate the plea on the basis of law, Mr. Mohanty states that he would need some time to prepare and submit his arguments. This on 27 June.
Yes.
This is all right.
weekly fresh admission. Item number 1, CRLMC 1860 of 2019.
Petitioner has died, Lordship. CRNC 1, petitioner has died, Lordship.
All right, anyway, petitioner has died. All right.
Yes,
The
Lordship.
petitioner
And,
states that the petitioner has expired. The petitions are disposed of as having abated. All right.
Item number 2,
None appears.
item number 3, item number 3,
None appears.
item number 4,
Whom I at liberty to raise all the grounds.
All right, permitting the petitioner to.
item number 5,
None appears.
item number 6,
None appears.
item number 7,
Same order.
item number 8,
Same order.
item number 9,
Same order.
item number 10,
May I please, Madam? Annex 2 is the affidavit sworn by the victim and informant. Under page 13, my lord, the informant himself said he has received all his money and doesn't want to proceed with the case, my lord. And similarly, another victim, page 15, my lord, swear an affidavit before Honored Sessions Court.
Or you see the affidavits of the informants stating that they have received the amounts from the petitioner and do not wish to pursue the complaint are on record. There is no objection to the prayer for caution. Accordingly, take from the prayer clause and all proceedings consequent thereto hereby quashed.
item 11,
None appears dismissed.
item number 12,
Same order.
item number 13,
Lordship, item 13 and 14, liberty may be granted to raise all the pleasure.
All right. Permitting.
item number 15,
My lord, prefer an adjournment.
For
Because
what?
I do not know the status of the case.
Sorry?
I do not know the status of the case. I may.
It's all right, sir. Then.
I prefer an adjournment.
No. Is it
One-
permitting the
one
petitioner to raise all pleas at the appropriate stage? The petition is disposed of. All right.
item number 16, item 16,
None appears dismissed.
item number 17,
None appears dismissed.
item number 18,
Same order.
item number 19,
May I please, Your Lordship, this case filed for quashing the order of cognizance along with the criminal proceeding, my lord. This is a matrimonial dispute and husband and wife present before Your Lordship, my lord.
They settled their disputes.
Yes, my lord.
All right.
I am for informant. Opposite panel 2.
All right. Counsel for the informant agrees with counsel the petitioner that the petitioner and respondent number, opposite party number 2 have settled their disputes this matter amicably. That view of the matter is safe from the prayer clause and all proceedings consequent thereto are hereby quashed.
They're staying together.
They're staying together. Have settled all their disputes and now staying together. All right.
Yes, madam. Cognizance as well as criminal proceeding.
Yes, yes.
Obliged, madam.
All right.
item number 20,
Item 20, my lord, I'm challenging the affair. I will raise all the points at this time.
All right. Permitting the petitioner to raise.
item 21,
21, 22, my lord, 21, 22. This matter is infructuous now.
All right. Disposed of as infructuous. All right.
item number 23,
None appears disposed.
item 24,
Item 24, Lordship. I have challenged the Annexure 1, Lordship. The petitioner is eligible to got the ration card, but in spite that she has got ration card and later he submitted deposited the ration card. As per the government instruction, Lordship, there is a notification that after deposit of the ration card, no penal.
And raise all these pleas, permitting the petitioner to raise all pleas at the appropriate stage. Petitions disposed.
Lordship, there is a notification already. I have notification, government notification. If there is a item
24.
deadline for surrender of cards with insertion
So
of
point this out to the trial court, sir. This you can point out. All right.
Item 25.
None appears.
Item number 26.
Same.
Item 27.
Same order.
Item number 28.
Same order.
29.
Same order.
Item number 30.
Item 30, my lord, the trial court has already acquitted the petitioners. Lord, I have filed a memo on 29th March before the document counter. My lord, a copy of the memo is Xerox copy of that, my lord. May kindly see.
A memo has been placed on record to the effect that the petitioners already stand acquitted by the trial court. In that view of the matter, the CLMC is disposed of as infractions.
Urgent copy.
Urgent copy.
Item number 31.
My lords, on behalf of BB Raut Rai, he is having some personal difficulty. I pray for an adjournment, my lords.
Let's just see what this is all about, sir. We adjourned, sir. 3 adjournments already granted. We say permitting the petitioner to raise all pleas at the appropriate stage. Petitioner is disposed.
Item 32.
None appears dismissed.
Item number 33.
Same order.
Item number 34.
Same order.
35.
Same.
Item number 36.
Same order.
37.
May I please, Lord? My lord, the petitioner has challenged the annexure 3, my lord. Sorry, my lord, that is annexure 2, my lord. My lord, case is that, my lord, after accused statement in 138 NI case, my lord, the warrant has been issued, my lord. And my lord, despite of efforts, my lord, kind have a glance, my lord, page number 17, my lord. And despite of efforts, my lord, the IIC Manchester police station has stated that several times raids were conducted, but the warranty was not found in the approach address and absconded from the given address. Therefore, my lord, the
agreed to appear will give you a date on which you can appear.
No, my lord. I am the complainant, my lord. I have filed one application, my lord, under section 82 of CRPC to issuing proclamation against the accused person, my lord.
All right.
And my lord, that application has been rejected, my lord, on the ground that by citing a judgment of our Honorable High Court of Orissa, there is no filing by the Lord and the SDGM that the persons have absconded or concealing themselves so that warrant cannot executed. Provision under section 82 of the CRPC are not complied with. And that principle is applicable.
Now comply with it.
My lord, it is complied. My lord, kindly have a glance on the
Anyway,
page
so
number
with passage
70.
of time, now you have to again comply. You can't now rely on the earlier compliance. You have to
Then
do
my
it
lord,
afresh.
kindly,
You have to do it afresh.
then my
Permitting
lord,
the
kindly give me
petitioner to
liberty.
take fresh steps in compliance with section 82 CRPC. The petition is disposed of. All right.
Item number 38.
None appears dismissed.
Item number 39.
None appears dismissed.
Item 40.
Don't again say none appears dismissed.
Item 41.
Same.
Item 42.
May I please, Your Lordship? On the ground of compromise by the opposite party number 2, OP2, my lord.
You're for opposite party number 2. Counsel appearing for opposite party number 2 tenders an affidavit stating that all disputes have been settled and compromised between the parties. In that view of the matter, takes the prayer clause and all proceedings consequent that we have quashed.
Oh, please. Okay.
Item 43.
None appears dismissed.
Item 44.
None appears dismissed.
45.
None appears dismissed.
46.
None appears dismissed.
Item 47.
Same order.
48.
Same order.
Item number 49.
Liberty may be given to raise the grievance in the court.
Permitting the petitioner to resolve peace of the property.
Let it be disposed of.
Yes. Item number 50.
None appears dismissed.
Item number 51.
Same order.
Item 52.
51. Petitioners filed the FIR and 51, and in the meantime, there was some gathering and the petitioner was no role at all and he was not there. But unfortunately, that case has been initiated against the petitioner. And challenging that, the petitioner has filed the case before this, my lord. And my lord, the petitioner is an innocent person, and my lord, the case has been initiated again under section 41, 294, 323, 5 years, 186, along with 30, against more than 50%. And the dispute rise below, the voting is there, and the election process started there, and some persons were gathered and they created the disturbances. And even though the petitioner was not there,
permitting the petitioner to resolve peace of the property.
Item number 52.
None appears dismissed.
53.
None appears dismissed.
Item number 54.
Same order.
Item number 55.
Same order.
Item 56.
You can pass it over.
Item 57.
None appears dismissed.
Item 58.
None appears dismissed.
59.
Same order.
Item number 60.
Same order.
61.
Same order.
Item number 62.
Same order.
63.
I'm sorry, my lord. I'm on VC, my lord. The lordship kindly have a glance. The page 23 of the petition, my lord. Here the department of where the present petitioner is working, my lord, he has specifically stated, my lord, the lordship kindly turn to page 24, where it was decided to ensure precautionary measure as per details below. A resolution has been prepared and in the community mobilized meeting that nobody will enter in the temple premises, especially unsafe area during the period of conversation. If any incident occurred in the temple premises, in the unsafe area during conversation work, the cultural department will not be held responsible. So, last similar observation also ADM Gonjam has already reported that, my lord. Thereafter, the last paragraph of that page 24, lordship kindly have a glance. Necessary steps in this regard, incident is purely an accident beyond control of executive. Although all the precautionary measures had been taken well in ahead, avoid possibly any mischief, taking into account the clarification supra, the allegation labeled against junior engineer, the executant engaged by the custodial department may be exonerated. And on this basis, no action was taken, my lord. The present petitioner, who is junior engineer, has been prosecuted under section 288 and 304A on the ground that he has not taken any precautionary measure while at the time of work, my lord. That is the allegation against the petitioner.
All right. Permitting the petitioner to raise all pleas in the appropriate station. Petitioner is disposed of.
Item number 64.
None appears disposed.
Item 65.
None appears disposed.
66.
Same on.
Item 67.
Item 67, I may be permitted to visit my lords. My lords, liberty may be granted to raise all these points at appropriate stage.
Right. Permitting the petition.
Item number 68.
None.
69.
Same order.
Item 70.
Liberty to framing of charge.
All right. Permitting the petition.
Item number 71.
Permitted to withdraw with liberty.
Mr. is withdrawn.
Item number 72.
Item 72 in rendered infractions, my lords.
All right. Disposed of his infractions.
Item number 73.
May I please, Your Lordship? My lord, alleged offences are available in nature as a petty quarrel. A matter is settled between the parties, my lord. While playing cricket, there was a abuse and there was a tussle between both groups. Both.
All right. The injured
And they have filed
affidavits.
Yes.
Stating that the issues have been settled between them. Between them and the petitioner. In that view of the matter taken prayer clause and all proceedings consequent thereto hereby quashed.
Item number 74.
None appears dismissed.
75.
Please. In this case, my lord, this petition has been filed to pass the order by which I have been issued with a process to appear in the court below in the SDGM Bhubaneswar in the case of 138 Act, my lord. My case is that I am no way involved with the issuance of the check or bouncing of the check in questions. And the process which has been issued, that has been issued by mistake of fact. So that process needs to be recalled and that should be passed by this honorable court as because I have nothing to do with the issuance of the check in questions nor bouncing of the check in question.
That you can point out to the trial court, sir.
Pardon?
You can point that out to the trial court.
Milord, things is, Milord, have a glance to the annexure 1, Milord. It will make it clear that 6, serial number 1 to 6, the name of the accused persons, they are from the company from which it has been issued. But I am not the person involved with that. I am a different company. I am a director of a different company and I have no nexus with the issuance of the check or transaction.
That you point out to the trial court, sir. This will have to be examined.
Milord, once the trial court has taken cognizance of the things,
you know that we don't have to
if your lordship
classes in
necessary direction in that regard.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of the interim order.
Trial to be completed within time schedule because
We will open to the
2017
parties to request the trial court to expedite the proceedings. All right.
Item number 76.
Oblige.
my presence may be there.
76.
None appears.
Item 77.
Same order.
Item 78.
Same order.
79.
79, Your Lordship, I am permitted to virtual mode, Your Lordship. On behalf of Mr. Padi, this file has to be transferred, Your Lordship. Since Union of India is a party, Mr. Padi cannot appear.
So that's all right, sir. It's only for the opposite party. That's okay. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. Right.
My appearance may be noted, my lord, for OP1 and 2.
All right. OP1 and 2 is approved. It's all right.
Oblige, my lord.
Item number 80.
None appears dismissed.
One pass. Pass to matter item number 56. Item 56.
I think you just say permitting the petitioner to raise or please the purpose. Yeah.